October 15, 2010. Which means that whatever interest she had in the home, she turned over to him, but they were still there. They were divorced in October, the final decree for divorce was granted on this all relates to his residency. And I want you to notice where these service was. Was when she transferred. I'm showing you, this is a trail of evidence that he owns the house where he's living, and he's been claiming somewhere else. I'm sorry. That's the only reason that I was in this. Yeah. Remember, that's opinion. This is the law.
I understand fully. And we also got the law that says on the 30-day requirement. I made this statement. Now, that is a law, 30-day requirement, right? I made this statement that is the window that we were using.
I am telling you the law, so that window you're talking about don't exist.
Your law is not questioning the 30 days.
If you let me complete, I can. The law questions the residency requirement, and if that doesn't question
But they do not argue the 30 days in your residency.
they are the residency.
Right.
The law, the charter of Vicksburg in terms of the election, tell you what the law is. This law tells you that the city has the authority to set under its charter whatever requirements are needed.
Well,
and the Supreme Court of Mississippi is verifying that.
Just to keep it moving, when we did our check, so the audience will know, we did the same check on everyone.
Did you have this law?
That law do not affect what's going on here today.
Yes, it does.
No.
Why doesn't it? It's a law of Mississippi.
We're working on the 30 day. We're not looking at his residency because his residency was passed. For the simple fact that he claimed the house free. The other resident, the other domicile that was in your law that you highlighted has been abandoned. When we did the check on it, the deed check and everything.
But when did he abandon it? When did they say he abandoned it? It was March of this year. March of this year. I would like to proceed if you don't mind.
That's when the deed was active, but it was something.
Even if it was 30 days, he didn't meet the requirements.
3-5.
If you're going, but the law.
Okay.
Even if it was.
That's what it was. So it was before our deadline. It was 3-5. Not only that, but once again.
If it was on the 5th, wherever he moved to in the city,
no,
he hadn't been there 30 days.
It was something. They're under contract or whatever.
He was still there. He had, in fact, I don't think he's moved yet. He had up to 6 weeks to get out of it. The point is, he was there.
He got the deed at 05, and the house.
No, he bought the house in June of 04. If he only sold the house on the 5th, where does the 30 days come in?
It was past our deadline. So he didn't own the property. He had abandoned the property. That's how we look at it.
Wait a minute. If he was there on the 5th.
Well, number one, we don't know he was there because now we're not using.
Well, I'm giving you evidence that he was still there. I'm giving you evidence that he was still there.
Move to the next one.
That's fine.
Have for Ms. Farmer.
Excuse me, Mr. Chairman. this gentleman is going to raise an issue about this funding. And I asked whether or not there was a written petition. And first of all, anybody got a petition has to go first and present the evidence to enable her to respond to it.
Would you ask him to sit down and get out of the way?
I agree with you, but the simple fact, he gave us the petition with no evidence. We chose, the board, the committee chose to hear the evidence, and we told him to come tonight. She would, if that became an issue, you would get whatever additional days you would need to respond to that.
Then he already makes the presentation so we can cross-examine him at the same time.
Well, so he's interfering with my time.
It's like I told you, Mr. Griffin. He's going to have to give me the evidence, we will forward it to you, and you will have whatever appropriate time you would need to respond if it came to an issue. It's like with Mr. Flagg, it's not an issue, what he's bringing up right now. So what you got?
The evidence that I was presenting you was to establish the fact that he owned the property and he lived in the property at 111 Laurel Lake Drive in the county. And that's where you're getting the additional evidence to prove that that's where he lived. From the time he bought the house with his wife in 2004 until he sold it recently. And he's still living in it, and he has a couple of weeks to get out. But at any rate, in serving those papers, on Mr. Flagg, after the agreement about the divorce, and that's the reason I gave you the decree and under the settlement. And if you look at the highlighted areas in, you saw where he was living when he was served those papers. He received those papers there. His wife had, and he had made an agreement on the divorce. He reneged on it, and they gave him, she had to file a contempt citation in order to get him in court to satisfy. And this document, this constraint document, and will you let me finish? I'm moving forward. I'm going to with Mr. We don't want my evidence. We can go to other places to get what I'm looking for. But I'd like to proceed in terms of doing it. I mean, if you're in a hurry, you shouldn't have showed up here.
No, I'm asking.
Okay. This is citation that he received delivered at that address that I gave you in terms of his address for contempt at 111 Laurel Lake Drive in order to do that. After that, George decided after the divorce, George had another deed of trust made up when he borrowed money for that house to pay for. Okay?
Point of order, I gave you the guidelines that we operate under.
Well, I'm telling you, why the Supreme Court said those guidelines are you operating under.
What you offered from the Supreme Court was said what I gave as our operating procedure earlier. We really don't look at the utilities or what have you.
Okay, that's fine.
Okay? Because that was the evidence she used, was her utility bills in the lease agreement. Now, David Day, again, I'm sorry, Dave, I have to use him as an example. He had his vehicle registered. And that's one of the things that passes on. There's two main pieces of evidence. Everything else can pretty much be manipulated. And everyone is manipulating something in some kind of way. And I don't understand that. Now, we're talking about people running for office, and we're saying, hey, just be straight, just put it out there. That's it. We have to do this on our own time and everything else. Just like I'm pretty sure you did this research on your own time. But we got our guidelines that we follow, and that's what we're going to follow. Now,
I'm trying to understand your point.
The point is we're using the 30-day guideline. For your argument to work for Mr. Flagg, we would have to be using the 2-year guideline.
No, even with well, I can understand that with Ms. Fondren, but Mr. Flagg still living in residence. He just sold it, as you said, he signed an intent to sell it on the 5th of.
That was the sale of deed that I viewed. I'm telling you.
And I viewed the same deed you signed, and I gave you information of the deed.
Are you going to present what you have for Ms. Fondren?
I'm not finished.
Well, I'm asking you.
I will get to Ms. Fondren when I finish with Mr. Flagg.
Well, just give us a, we don't need the narration. Give us what you have.
No, but you do want to do it.